Hi, everybody, and thanks for joining our webinar today. My name is Dan Rudderow. I'm an attorney. I've been practicing law now for about 25 years. Our law firm, Rudderow Law Group, represents the owners and managers of manufactured housing communities as well as RV parks throughout California. We have attorneys at our firm who prepare rental agreements and park rules for our clients' communities. We also assist parks with day-to-day operational issues. Our firm also prosecutes eviction proceedings when necessary, and we also represent the owners and managers in a variety of litigation cases. Today, I'll be talking about how to handle heirs when a homeowner passes away. Our clients often have a lot of questions about how to handle heirs. So we thought it would be useful if we gave this presentation on the do's and don'ts when dealing with heirs. This webinar should be about 30 minutes long. During the webinar, you can submit written questions by clicking the Q&A. Time permitting, we're going to try to answer your questions if there are any. If your question was not answered, or if you later think of a question after this webinar ends, feel free to email me at dan@rudderowlaw.com, and I'll be sure to get back to you with an email or phone call. There will also be a poll at the end of the presentation where we ask for your input as to what you liked and didn't like about today's presentation. And also, we're going to ask you what topics you would like us to cover in future webinars in 2020. Okay, so let's get started. As you can see from our first slide here, we had our IT team give us some cartoons to make today's presentation more fun. This one is supposed to be the heir who finds out they inherited someone's mobile home. And I'm just, maybe it's the num lock right here, undo that. Yeah. We're just going to the next page. There we are, and then it's gonna go, oh, great. So we begin, of course, with the death of one of our homeowners in the community who owned their mobile home and had rented the space at the community. Generally speaking, when your homeowner passes away, the homeowner's rental agreement with the park is considered terminated. So generally what that means is that the contractual obligations owed by the parties under the rental agreement end and do not exist anymore. But what happens to the home? The home is obviously still there in the space after the homeowner's passing. The answer is, it depends on whether the deceased homeowner has any heirs or other persons who inherited or gained ownership of the home after the person's passing. Sometimes, as we know, the homeowner dies without anyone inheriting the home. Other times, there could be one or more persons who notify the park that they have inherited the home. When there is an heir or heirs that exist, California's mobile home residency law, Civil Code section 798.78, also known as the MRL, affords heirs, along with joint tenants and personal representatives of the deceased estate, with a qualified legal right to sell the deceased homeowner's home to a third party without having to remove it out of the park. But this is a qualified or limited right. The law says that the heir has the right to sell the home, but only so long as the heir pays the rent owed under the deceased homeowner's rental agreement and performs any necessary maintenance work to the home. Otherwise, if the heir fails to pay the rent or fails to perform the necessary maintenance, the law says the heir may lose the right to sell the home in place, in which case management may require that the home be removed. So, whereas I just told you earlier that when the homeowner passes away, the deceased homeowner's rental agreement also terminates and no longer has any effect generally. In this context, having to do with the heirs, the rental agreement sort of lives on or still has relevancy insofar as the fact that the heir must pay the rent and perform the maintenance obligations that were required under the deceased homeowner's rental agreement in order for that heir to have the right to sell the home in place. So, in order to make sure that the park does not run afoul of an heir's legal rights to sell the home at the park, community managers usually make some effort to see if the deceased homeowner in fact had any heirs. And if so, usually make an effort to reach out to the heirs so that arrangements can be made for that heir to pay the space rent and sell the home. So the first step is we need to determine if the deceased had any heirs. Sometimes it's easy, since the heirs themselves will oftentimes come down to the park office and introduce themselves to the community manager and advise the community manager that they are the heirs who inherited the home. But when no one comes into the office, figuring out if there are any heirs usually involves a little bit of research. And that research can involve reviewing the deceased tenant's file to see if there are any family members or next of kin or people that the homeowner put down to contact in case of emergency, anyone that the park manager sees might have inherited the home. After determining who the heirs might be, because we'll never know for sure, but after giving it our best guess of who the heirs might be, park managers then usually send a letter to the potential heirs asking them to come to the park office to make arrangements for the payment of the space rent. It is generally a good idea to express condolences at the beginning of your letter, since the heir may be in mourning and a little sensitive to your request to take care of business and come down and pay the rent right away. The letter should request that the heirs come into the office to go over the rent that needs to be paid, any maintenance that needs to be performed, and any insurance that needs to be maintained on the home. It's generally a good idea to ask the heir to contact the park within a certain period of time. For instance, perhaps you say in the letter, please contact the manager within the next 14 days or 15 days. Otherwise, the heirs may be slow to respond to your letter. And you obviously want to get this taken care of as quickly as possible, since you want to make sure that all of the space rent is being paid and that there is no loss of rent to the park. You can mail one letter addressed to all of the potential heirs, and you should also mail a copy to the home itself and address the envelope to the estate of the deceased homeowner. Oftentimes, an heir will visit the home and collect the mail and then see the park's heir letter and be advised that they need to come down to the park office. Sometimes there will be multiple parties that come into the office claiming they're heirs and submitting various documents, such as they'll bring you a will or some type of living trust or living will or some type of trust that they want you to look at. Typically, neither you nor even your park attorney are going to review or analyze these documents or make any determination as to who legally, in fact, the heir is. What typically happens as a practical matter is that the manager or the park attorney simply explains that someone needs to pay the rent. The heirs can then themselves figure out later who actually inherited the home and have the right to sell the home. If no one is inside the home, your company may have a policy of wanting to consider disconnecting the utility service, since no one's in the home and the lack of operating utilities may deter anyone from trying to become a squatter in the home. Next, we really want to recommend that you document how you're accepting the rent. And this really should be step 2, and I didn't put a step 2 at the top of this slide, but if I had to do this little slide over, I would have put step 2, document. When the heir comes into the office, they are paying the space rent. And anytime you are accepting rent from someone, you always have that risk that you may inadvertently start an oral tenancy with that person by accepting rent from them. So to avoid any claim that you started an oral tenancy with an heir when you accepted rent, it's important to document that you are accepting the rent from them as an heir and not as a new tenant with a tenancy. So the question is, of course, how should I document that I'm accepting rent from the person as an heir and not a tenant? We generally recommend to our clients that they have the heir sign some acknowledgement form whereby the heir signs a piece of paper acknowledging that they are paying rent as an heir and that no oral tenancy or any tenancy whatsoever is being created by the park's acceptance of rent. Our law firm has an acknowledgement form we suggest our clients use, and you can reach out to me after this presentation if you're interested in obtaining the form. One question our clients often have is whether it's a good idea to have a formal contract or storage agreement signed by the heir. And I think in this area, park management companies and park owners will get different opinions by different lawyers. I generally feel it is probably not a good idea to have a formal contract signed. I say that because at present, under the law, heirs only have a very limited statutory right under the civil code to sell the home in place. But if the park then has the heir sign a contract, somewhat like a storage agreement that's 2 or 3 pages long, there's this possibility that the heir could then later claim in court in front of the judge that they also have contractual rights in addition to the statutory rights already given to them to sell the home. Bottom line, we want to comply with the law on the books without doing anything that would expand the rights of heirs or make things more complicated than they have to be. If we keep things very simple in front of a judge, typically our court appearances go a lot faster and we're not having to spend all day in court, which at the end, that affects the company's bottom line. So after meeting with the heirs, and accepting the rent and having all that properly documented that we're accepting rent as an heir and not as a new tenant, the next step, I would call this step 3, is to closely monitor the situation. Meaning, management should keep track, obviously, as to whether the heir is timely paying the rent every month. Management should also closely monitor the condition of the home. If there are maintenance issues which have arisen after the homeowner's death, such as, for instance, if you had something like weeds growing up in the flower beds in front of the home, management should inform the heir that the maintenance work needs to be performed. Clients often ask me if that should be done through the use of a 7-day notice. It would be best if you do not use a 7-day notice. The 7-day notice is something you serve on a homeowner who has a tenancy in the park. And it's something you need to serve on a homeowner before you evict them for violating your park rules. Heirs have no tenancy and they are not being evicted per se. So for that reason, you should not use the 7-day notice. So instead, you can simply send them an email or a letter advising them of the need to perform the necessary maintenance. Sending them something in writing is generally a good idea since it will document that you asked the heir to do the maintenance. And going back to a moment to what I was saying about acknowledgement forms, generally I would recommend some type of an acknowledgement form being signed, but like everything in the law, there are exceptions and special circumstances in each case. So you should consult with your attorney when you have questions. This presentation is obviously not to give you legal advice, but just today during this webinar, we wanted to give a general discussion of some of the issues that we see often come up with respect to heirs. Management should also keep a watchful eye out for any heirs or other persons who attempt to move into the home, especially squatters. This happens more often than you would think for some reason, even though you have a homeowner who is in the home who passes away and their children live in Idaho, somehow it happens that children come out of the woodwork and they come over to California and they start taking inventory of perhaps their deceased parents' belongings. And one thing leads to another, and they're now living in the home. They're actually spending the night, and their cars are left in the carport area overnight. Management needs to explain to these heirs that they're not allowed to live in the home. Obviously, there's a lot of reasons for that. We don't want heirs living in the home, coming down to the park office, paying the rent, and suddenly it might look like to a judge or someone in court that we were treating them as an oral tenant by allowing them to spend the night constantly or even one time in the mobile home. So it's really important that management make their rounds, that they're keeping a close eye on this home, that they're making sure that this home remains vacant, and that the heirs, while obviously they're probably going to visit the home, and perhaps they're doing maintenance or something else or with the home or the belongings, it's important that management communicate clearly to the heirs that they're not allowed to live in the home. If the heir persists in living in the home, you can send them letters and emails reminding them in writing, again, documenting that you as the park manager are telling them, the heir, that they are not allowed to live in the home. If they persist to live in the home after that, you probably want to discuss the matter with your park attorney. Oftentimes, it's necessary to serve the heir with a 5-day notice to vacate the premises. And then if they still don't vacate the premises after 5 days, you or your attorney will need to file a court proceeding to have them removed by the sheriff. I recently had a case in my office where the homeowner died and the family told the park manager that they were going to have one of their family members who had trouble holding down a job live in the home while the family went through the legal probate system to determine what they were ultimately going to do with the home. The family, funny enough, thought that that was a great plan, or at least a great plan for the family. Our office got involved and we had to explain to the leader of the family, possibly I think he was the executor of the will of the deceased homeowner, but explain to the leader of the family that the family member could not live in the home and that one person in the family needed to make sure that the rent was timely paid every month. Otherwise, the entire family would lose the right to sell the home in the park. They understood, and once they were advised of what they could and could not do, we were able to get their cooperation and have them not stick in one of their family members to live rent-free in the home, essentially, and we were able to get one family member to come down to the park office and to pay the rent every month. Of course, with my last cartoon here, of course, even though a person who is an heir can't live in the home, that heir is free to apply for tenancy like any other member of the public. The MRL actually talks about that in the law, that these are the rights and obligations of heirs, but the statute goes on to say that the heirs themselves may submit an application for tenancy with the park manager like anyone else and be approved for tenancy. If the heir's application for tenancy is approved, then the heir will sign his or her own rental agreement and thereby become the new homeowner with a new tenancy. And then that will be the end of it. The heir will move into the home pursuant to a new signed rental agreement. The heir will now be the tenant. They will no longer be the heir. And now you really have executed a new rental agreement, which will replace the deceased homeowner's rental agreement. We've been discussing today what happens when there are heirs and how to deal with them. Oftentimes, of course, what I said at the beginning of this webinar was there are going to be times when the homeowner passes away without heirs. Or there's going to be situations where the homeowner passed away, they had heirs, but for some reason those heirs are unwilling or unable to do what they have to do in terms of paying rent and performing necessary maintenance, such that even though there are heirs who have inherited the home, they're not doing what they need to do under the law in order to have the legal right to sell the home. And in which case we treat those people as not heirs at all. So there are going to be times when we look at a situation and we say this homeowner passed away, they didn't have any heirs, or this person passed away and had heirs, but not heirs with any statutory right because the heirs in this particular situation didn't do what they were supposed to do. When that happens, when there aren't any heirs, what you do in that instance is you typically, again, not one answer fits all, but typically you'll see that what the park can do is conduct a warehouseman's lien sale of the home. And our office does them all the time, or you can have your own park attorney do them. I know some management companies do them themselves. It involves, it's basically a lien sale, and it basically entails preparing the proper lien notice and then publishing that lien notice in a local newspaper for a certain period of time. I think it's about two weeks. And then you conduct the lien sale in front of the home. And we assist our clients with telling them how to go about doing the lien sale. And we can give you instructions about how to show up, what to say at the lien sale, and see if there's anyone there who wants to purchase the home. Typically, in 99% of the cases, our experience is that not that many people or no one show up at these lien sales. And so typically you're going through a process of conducting a lien sale, placing the ad in the newspaper, physically actually conducting the lien sale in front of the home. But when no one shows up, you're then coming back to the park office and you're processing the paperwork to have HCD transfer title from the deceased homeowner into the park's name. So the bottom line here is by doing everything that we talked about today, we talked about understanding that it's probably a prudent business decision to at least make some attempt to determine who the heirs are and to try to reach out to those heirs with some type of letter so that we don't go straight to a warehouseman's lien sale and then find out after we went to a lien sale that there's a couple heirs that come out of the woodwork saying that you've infringed on their rights and they're upset at the park, and the heirs have hired an attorney who's going to file a lawsuit against the park because you jumped the gun and went to a lien sale rather than trying to make some effort. The law doesn't require you to make an effort to find out who the heirs are, but it's just this situation that if someone passes away and you went straight to a lien sale, you're gonna just have a nightmare with heirs coming out of the woodwork and saying that you interfered with their right to sell the home in the park. So although not required, looking at what the statute says, as a good business practice, manufactured housing communities have made some attempt to find out who possibly the heirs could be, at least send a letter to the home addressed to the estate of the deceased homeowner in case anyone is picking up mail, and then making efforts to have them come into the park give them an opportunity to do what they need to do to exercise their rights in paying rent. And then if you also then document the fact that they're an heir, then you stay out of legal troubles later on when there is a dispute. Oftentimes, our office receives files from different owners and park managers about what they can do with a possible heir situation. And it really helps the legal department, whether it be an attorney or your in-house counsel, if there's documentation in the file that establishes who these different people are, who is the heir, what did we do, do we accept rent from them, do we accept rent from them as an heir? And then also, like we talked about today, it very much helps avoid problems and having to contact a lawyer if you're on top of managing and monitoring the home. If you're managing and monitoring the maintenance that needs to be done on the home, if you're sending appropriate emails and letters to the heirs advising them of the maintenance they need to do at the home. And it very much helps if you make sure, to the extent you can, that there are no squatters in the home that are, you know, inappropriately spending the night there, and someone that may start to look like they think at least they have an oral tenancy. So if you do all these things, you are protecting the community from potential litigation, from mistakes that might occur in dealing with the heirs. You end up, while following these guidelines, you end up keeping up the appearance of the home, making the community look good, and attracting a new, good, qualified homeowner into the community who's going to like that home, like the community, and buy the home from the heirs. And then, important to the bottom line, you're going to minimize or eliminate the rental loss to the park if you try as smooth as possible to go from the homeowner who is paying the rent and now is deceased to now having an heir pay all of the back rent and all the present rent and all the future rent that they're obligated to pay, so that there's no loss in rental income to the park. So I want to thank you for joining our webinar today. I think we went 26, 27 minutes. I do have one question that popped up that someone submitted. The question is, the resident passed away without leaving a will. Someone claiming to be the daughter comes forward and wants to pay the rent. Should we accept? I think we covered that today in the sense that we're not really interested in the will or the lack of a will. This is going to happen every day, where you have homeowners who pass away, and your job is to, if it's appropriate, to have the heirs come in and accept rent and document that they are the heirs. So on this question, my answer would be yes, you can generally accept the rent. What's important is to document that this daughter you are accepting rent from the daughter as an heir. Let me answer just a couple other questions that popped up. Similar question I have here. What kind of proof do you need from an heir to confirm they are an heir? How do you handle the situation with multiple heirs contacting the park, i.e. brothers and sisters fighting over control? When I was studying this issue several years ago, 5 or 6 years ago, I had the same question in my mind, thinking through it logically. How was I going to know if two different people claim to be the heir and they both are submitting paperwork to me? And what do I do in that situation? It's a great question. It's the question I had in my mind. And the answer is it pretty much doesn't happen exactly like that. Usually a family can get together, like I said in my example, and they can bring you the rent. I have not had a situation yet in my office where we really have two different people who claim to be the heir. Usually it's several people are claiming to be the heir, but the family as a whole gives us the rent check. And usually it's because someone is writing a check out of their own pocket. Usually it's the person who knows that they're an heir wants to do that. And the other part of this is there's just, if you think about it, there is no way you or even an attorney are going to be able to look at documents to determine who is the heir. If something like that was litigated, it would probably go through a probate court, and it would go through a trial, and some judge would be hearing witnesses and testimony and looking at wills and trust documents. And then someone, probably a judge, would make a determination who inherited what and who inherited this mobile home. So the way you handle it is try to discuss it with the family, what they can do as heirs, how the family can sell it, and you can accept the rent. And if you really have a situation like this where you have two competing heirs, both with their own paperwork, and they don't get along, probably you can reach out to your district manager, someone up the chain of command, or reach out to your attorney. The next question is a really great question. How long should a park give the heirs to bring the home into compliance with park rules and regulations? And how long should we give them to sell the home? Interesting, the MRL doesn't give a timeline as to how long the heirs have to sell the home. I think the thinking is that heirs are not going to pay the rent out of their own pocket for very long. They're motivated to sell the home so they don't have to pay the rent out of their own pocket. I was with a group of park managers 2 weeks ago, and they actually informed me that they have had a situation where the children inherited the home and they're very sentimental, and for over a year or 2 years or 3 years, this family has paid the rent and maintained the home without selling the home. And for that particular community, they were okay with that. I suppose you can work with your manager or your attorney if it comes to a certain point where you think they're not doing the necessary maintenance or they're squatters in the home and you want to cut it off and develop ways to do that. But so far under the MRL, there's no precise timeline as to when they have to have this done by. Your first question, though, is a really good one. How should a park give the heirs, how long should a park give the heirs to bring the home into compliance with park rules and regulations? You know, with our homeowners, if it's maintenance or something with the home, we typically, as everyone has heard me say and other attorneys have said, we try a 3 strikes and you're out approach. I mean, we do give the 7-day notice to the homeowner to perform the necessary maintenance and compliance issues. And we might give them a second 7-day notice and perhaps a third. It's generally a good idea to do the same 3 strikes and you're out. Every case is going to be different. But you know, when you look at a particular case, you're going to have to decide if the maintenance issues are so horrible that they constitute a real threat to health and safety of other people in the park. If it's one of those compliance issues or maintenance issues, then you might want to send one letter to the heir saying that this maintenance compliance code issue needs to immediately be addressed and give them perhaps 10 days. And if they're not making an attempt within 10 days to even start compliance or make the repairs, then you and your park attorney can discuss what options you have from there. At a certain point, when the heirs don't do what they're supposed to do, either in paying rent or performing maintenance, there is going to come a period of time that the manager and the owner need to make a determination when they're going to say, this is it, heir. This is my final warning. You need to take care of these compliance issues. And if you don't do this in the next 7 to 10 days, then the park will take the position that you've lost your right as an heir, and then go from there. And our office has taken that position occasionally. Occasionally we've handled files where we inform the heirs that they lost their right to sell in place because after repeated requests, they have failed to do what they were supposed to do under the deceased homeowner's rental agreement. And I think the last question I sort of answered as well, is there a reasonable amount of time an heir can stay at the mobile home while performing maintenance and repairs on the property? A different question. And I think my answer is do not let them stay. do not let them stay at all. Um, you know, the lawyer will tell you that we really would prefer you keep things black and white and very cut and dry. Heirs should hopefully be able to come to the mobile home, and maybe they're doing repairs during the day, but you know, we would prefer not to allow an heir to spend the night. Once they start spending the night there overnight and staying there for periods of time, now you've really blurred the lines between whether or not this person is an heir or an oral tenant. I understand that maybe the heirs are family members who are out of state. They fly into California. They're not going to stay at a hotel. They're going to come into the mobile home and do repairs, and you find that they have spent the night. You just need to be on top of that and tell them that they can't stay there. And most people, I think, will understand that. I mean, there's liability issues, the fact that, you know, we don't know who's coming and going in a mobile home, and that we're responsible for the health and safety of the entire community. And I think you'll get cooperation most of the time from heirs that they are going to have to stay elsewhere. If that's a hotel down the street, but they can't stay in the mobile home. Next question is, what happens to the property of the deceased under a lien sale? It goes to the park typically, like I said. Is there any duty on the park to hold them or store them for any period of time after the sale for the heir to collect? That hasn't really come up. I don't think there's a precise time or duty there. I'd have to get more information from you, and feel free to give me a call or send me an email to give me a little bit more background on what you mean by duty and what the scenario is there. Last question, do we have to file anything with the court before a lien sale is done? No, you don't. The lien sale can be done with the proper notices and with publishing it in a newspaper. Next question, if the home has a sprinkler system, do we still need to turn off utilities and the water? You know, I think you should speak to your attorney about that in terms of any safety issues you're seeing with a sprinkler system or fire system. Again, if the homeowner has passed away, there is no one in the home. And so turning off the utilities shouldn't be a safety issue, but your question is kind of adding a sprinkler system to the utilities. And I think that probably someone needs to look at that and say, are there any risks to turning off a sprinkler system? The next question is, rent has not been paid and we are getting ready to serve a 360. We should name the decedent and the decedent's estate and any known heirs, correct? When do we name the public administrator? Feel free to reach out to me and maybe we can talk about this offline, but typically if the homeowner has passed away, like I said, the rental agreement ends with that homeowner, and the heirs have a limited right to pay the rent and sell in place. If the heirs have not paid the rent, then they've lost the right to sell it in place. Typically, you're not going to serve a 360 on an heir. Why? A 360 is something you use to terminate the tenancy of a tenant, and the heir does not have the heir is not a tenant. So I think you probably should talk to us or talk to another attorney, because this question kind of presupposes you need to serve a 360, and I think that's probably, before I learn more about your case, that's probably not the appropriate notice. And then how many days do we wait to call HCD to do a transfer in case no one shows up at the lien sale? When no one shows up at the lien sale, you can immediately process the paperwork with HCD to transfer title to the park's name. HCD is going to take a long time, but it's like dealing with the DMV. But you can submit the paperwork to HCD immediately after the lien sale in most cases. Does the last question I think I have here is, does the heir has to sell the home? Can the home remain vacant as long as rent is paid and is kept up to the park rules? Like I said earlier, in theory, if heirs are willing to pay the rent out of their own pocket and perform all of the necessary maintenance, there is no time limit right now under the MRL as to how much time they have. And I have had park managers tell me that some heirs have paid the rent, kept the home vacant for years. And for some reason, the park's okay with that because although the home's vacant, the maintenance is perfect and they're collecting the rent. All right, well, I want to thank you for attending, and these have all been really great questions. Feel free to reach out to me after this webinar, and at this time, we'll go offline. Have a great afternoon.